Hi, I'm Anthony Alder from Alder IP, and welcome to another episode in the IP series. Today we're going to be talking about what to do if you receive a cease and desist letter. A cease and desist letter is a letter usually from a lawyer or from a person that says, stop doing this, you're infringing my IP. If it's from a lawyer, we have to treat it slightly differently to if it comes from an individual person. If it comes from an individual person, the chances are that that letter that you've received is what's called an unjustified threat, which means it hasn't gone through the proper legal review, it doesn't have a lot of grounds in it that are actually enforceable under law, and some of it is usually in the category of a bit of a rant. So often, if it's come from a particular person, it's probably of less value or of less of a worry than if it's come from a law firm. If it's come from a law firm, you need to be very concerned about it. And part of the reason is because the law firms actually looked at your case and worked out that they've got a prima facie case against you at least, okay? Because no law firm, well, particularly in Australia or the USA, would send you a letter on their letterhead unless they thought that it was backed up and supported by law. So if you do receive one of these letters, the first thing you should do is read it very carefully. Look at the dates of responses and then contact someone who really knows what they're talking about. You really need to talk to an IP lawyer and think about what is it that this person is complaining about. You should assess with the lawyer whether you actually have infringed and done the things that are listed in the letter. You have to be honest about this, particularly with your lawyer, and you have to talk about what is the scope of this. And this particularly is very, very relevant with trademark infringements, because quite often the trademark infringements are quite innocent sometimes, and they're just accidental. And if that's the case, you need to talk about it with your lawyer about the consequences of that. If you think there is some kind of overlap or confusion, particularly with trademarks, and that there has been infringement, you need to stop using it straight away, right? And I can't say this strongly enough. You need to stop the damage from occurring. You then need to have the lawyer respond to the cease and desist letter in a timely manner and make sure that it's closed off. The last part that you really need to consider is damage, legal damage for the cease and desist letter. In Australia, the legal damage goes from the time that you are notified or knew about the infringement. If the letter was sent to you and you continue to infringe, then the damage keeps continuing to go up. And that's why it's important that if you think you're infringing and you can possibly do it, stop using it. Because if you stop using it, then the damage is cut off at that time. Particularly if you didn't know about the infringement before you received the letter. It's a bit of a different story if you knew that you were infringing from the start. Because if you knew that you were actually infringing from the start, then your damage goes from that very time that you started. And that's probably catastrophic to most businesses. So you really need to assess that, and you really need to have a look at that. The other thing is also in the US, and to a lesser extent in Australia, the other side or the person who's sending you the cease and desist letter can request punitive damages or willful damages. In the US, willful damages is 3 times the amount of damage and legal cost, which can mount up very, very quickly. In Australia, punitive damages is limited, but it's only for really gross infringement type situations. But it does occur, and it particularly does occur if you continue to infringe after you've been notified with a cease and desist letter. So really try and avoid a situation where you're up for punitive damages if possible. The best way to do that is to stop using it when you do receive a cease and desist letter. And the second way is go talk to a lawyer. Go get a lawyer's opinion about whether you're actually infringing or not, and then they can take on the case and respond for you. I hope this has helped you understand what to do if you receive a cease and desist letter. If you have any queries about cease and desist letters, or you'd like to talk about it with one of our trained professionals, please feel free to contact myself or my team at Alder IP, and we're more than happy to help you. Thanks for listening.